Hi, welcome to Preventing a Parental Alienation Train Wreck. I'm Dr. Mary Alvarez, a licensed psychologist here in Texas, practicing in Austin. My practice is almost exclusively high conflict family law matters that often involve parental alienation. My colleagues joining me are going to be Lisa Rothfus and Chris Turner.
And I'm Lisa Rothfus, and I'm a psychotherapist here in Austin, Texas. I've been working with children and families in the field for about 37 years. Right now, I do most of my work in reunification therapy with families, and I also work with high conflict and parental alienation, and I do mild, moderate to severe treatment for parental alienation cases. Chris?
Thanks. Hi, I'm Chris Turner, and I am based in Houston, Texas. I'm a mediator in private practice. I do a lot of work with severe cases as well. And in addition, in my mediation practice, I work with pro se litigants, people representing themselves, as well as those families that are in mediation due to high conflict situations.
And we've been fortunate enough, the three of us, to work on a lot of cases together and to do some presentations. So we're excited to be here today to talk to you about this.
So the format is going to be this. We're each going to present information concerning a real case that is very typical of severe parental alienation matters that are moving through the judiciary. So each one of us will take a segment and discuss with you various issues and factors and variables related to this particular case. Okay, so let's get into the case. In order to do that, I want to present a couple concepts to you that are very, very important as we continue to understand through the science and research exactly what parental alienation is, what it entails, and how the risk factors increase from mild to moderate to severe, and what those risk factors are. So prevention and early intervention are the key components now as a field. We have got to master early intervention, if not prevention. And I'll discuss a little bit further along in my presentation what that really means. And I know my colleagues will also talk about that. But prevention and early intervention. The other key concept that I want to discuss here on the front end, because it's always going to be your backdrop when you're working in this field, or if you are a parent of a child from whom you are alienated, is the concept of developmental trauma and toxic stress. These children don't come through development being alienated from a formally loving parent unscathed. And there is a wide variety now of research from neurological development and psychological development that shows the potential consequences to children when developmental trauma and toxic stress are part of their life. And we know that this is the case when a child is living in an environment not only of high parental conflict, but an environment that involves one parent trying to disrupt and or destroy the relationship between the child and the other parent, because that is not a normal trajectory for children developmentally. And so the toxic stress response is what happens inside of the child. And when the toxic stress response remains in the on position, there are potentially very significant developmental consequences and potentially significant changes in the brain that can occur. So let's move into this real case. I call this a real case, a typical alienation case, because it is. I mean, not only is it a real bona fide case that's involved in current litigation, but it's a case that we see over and over and over again. So some of the facts about this case include, just briefly, the parents married, they had a child, and they divorced all within a very short period of time, all within about 22 months. So that should be red flag number one, that this relationship was never stable. It wasn't stable from the beginning. Now, they had a child very early on, and so that complicated matters. Modification number two is your second red flag. While it's not entirely uncommon for one parent or the other to file a modification to change something post-divorce related to custody or child support matters, by the time there's a second modification, everybody involved, from the judiciary to professionals to the attorneys, should see a red flag. So this particular modification was filed 6 years ago. So this case is going into year number 7, unresolved. And it is at this second modification where prevention was possible, all right? But we're now in year number 7, and it's no longer a prevention or early intervention matter. It's kind of a crisis level matter now. So since this second modification was filed 6 years and counting ago, I went into the case notes in the judiciary and I counted the number of entries that have been posted for all the various activities of a case, from subpoenas being issued to resets to discovery to hearings and all of those matters, motions for an amicus, motions for a psychological evaluation, etc. There are 463 entries in this case. That's an overwhelming number of entries, meaning activities involved in this case over the course of 6 years. And remember, this child has been living this for the last 6 years of his life as well. So modification number 2, as I mentioned, is entering year number 7 without resolution, on the horizon, according to my reading, of the case history. The child, when younger, did not reject the father. So there is a protective factor of age. And Lisa will be discussing this in a little bit more detail, and perhaps Chris as well. So along the way, the child, although alienation tactics were being used by the mother, the child was still able to enjoy a relationship with his father. And they were still able to spend time together, and he benefited from it. As he grew older, into the 11 and 12-year-old range, things shifted dramatically. So now that the child is older, he is more susceptible to the effects of alienation tactics. Those are the things that the favored parent engages in order to disrupt and or destroy the relationship between the child and the parent. And so now that he's older, those things are able to be processed neurologically and developmentally by him at a different level. And he started to reject his father. And as of now, 2024, early 2024, this child hasn't seen his father in 7 months and counting. So there is now currently severe alienation. And it happened fairly quickly over the last year and a half or so. Things deteriorated rapidly, in this matter. So some other case highlights so that I can set the stage for my colleagues to continue this. Red flag, number 1, longevity of the case. So again, I'm going to take you backwards. This case, the modification number 2, was started in 2017. It is now 2024, so we're starting year number 7 of this modification. In 2019, there were findings that the mother was at risk for engaging in alienating behavior. She had the constellation of personality characteristics and traits and behavior up to that point that indicated she was at high risk for engaging in these behaviors. Nothing was done, okay? Those findings were significant. Next finding, in 2022, there was a finding by that point, 3 years later, that the mother was engaging in alienation behavior. She was using the tactics that we have identified that cause children to, over time, reject a parent. By 2023, the child was completely rejecting the father. All right, so we went from 2019, a red flag was raised to the court that indicated the mother was likely to do this. By 2022, it was confirmed that the mother was engaging in alienation behaviors. And by 2023, the child was completely rejecting his father. So no expert in treating parental alienation was ever authorized or ordered by the court. The court did order evaluations and determinations of parental behavior, but as far as treatment, nothing happened until very, very recently, when the child was ordered into individual counseling. And unfortunately, the father selected a provider based on his insurance panel, not based on credentials or background in parental alienation. There has never been a family therapist or a reunification therapist ordered by the court with, again, the background, credentials, knowledge, and understanding of parental alienation to make a real difference, in this matter. All right, so what we have found in the trajectory and longevity of this case is, despite it being in year number 7, besides the court ordering a determination of parental psychological characteristics and behaviors, and the court ordering an examination as to whether or not either parent was engaging in alienation, no other professional has been involved that has a background and the credentials concerning parental alienation. And so this family has been left at the mercy of the judiciary, who also don't understand parental alienation and make decisions, unfortunately, based on information that is inconsistent with the knowledge and research that we have concerning parental alienation. So while the child just recently was ordered into individual counseling, the counselor was selected based on an insurance plan. It was not selected based on knowledge and understanding in parental alienation. There has been to date no family therapist or no reunification therapist ordered by the court. Again, if that was going to be the case, the same issue applies. There needs to be somebody who is well versed and understands and has read at least some of the research in parental alienation to understand a lot of the contradictions that we deal with that present one way but actually work in reverse. And so where do we go from here? As I kind of outline this case for you and send the baton off to my colleagues, we have the science. All right, the science is indisputable. We have the research, which is now a good body of research. It's not just a couple case studies or a published study here and a published study there. There is now about 25 years worth of solid research that has built on each other, which is the purpose of research, in order to expand our understanding and our knowledge of the field of parental alienation. We know the terrible potential outcomes that can happen to children. We have the research on brain development and neurodevelopment that help us understand what toxic stress does to children, and developmental trauma, what that does to children. And parental alienation is considered one of the ACEs, the adverse childhood experiences, and ACEs are considered developmental trauma. So connecting all these dots for you. So we have all of this. So what's going wrong? What's happening? Where are the shortcomings? Well, first of all, the judiciary is severely undertrained in knowledge about parental alienation and in science and research, severely. And that includes judges and attorneys, amicus attorneys, and other people associated with the judiciary process. Professionals, mental health professionals, pediatricians, school personnel, school counselors, also severely uninvolved in understanding the research and the science that we have. And so they too inadvertently make lots of mistakes along the way that further promote the agenda of the favored parent against the target parent. So back to coming full circle, where we need to go with this to prevent a heartbreaking case that you're going to hear more about from my colleagues that I just presented the skeletal information is prevention and early intervention. We have to do a better job at intervening much, much sooner in the process to prevent these long-term consequences to children. So I will end my segment here and pass it to my colleague.
Thanks, Mary. I think one of the things that we don't talk enough about in these cases is the effects of toxic stress on the child and how that affects them over their development. So I think it's really important that you brought that up today.
Thank you. Thank you. I'm glad that came across.
Yeah, I think one of the things in addition to that was the developmental age of the child and the biological age of the child that plays a factor in parental alienation.
Absolutely.
Really key in when we get these cases, which is why prevention, early intervention is very important. I hate cases where we get them and they're severe already and the kid is aging out of the system and parents want to know what they can do. That's a hard position to be in.
Right, because at that point, there's oftentimes not a lot that you can do.
Unfortunately.
Yeah.
Unfortunately.
All right, so the next segment, I'm going to be talking about some therapeutic issues with this case.
What I'd like to do today is to go a little bit more in depth into the 7 therapeutic errors I think that often derail parental alienation cases. Let's start by talking about the number one biggest error I see made in these kind of cases. And that is where court-ordered family therapy or reunification therapy is not ordered. And of course, in this case, it was never ordered. But what is the difference between court-ordered family therapy and reunification therapy? And I want to say that in a lot of states, people don't even know what reunification therapy is. A lot of times, lawyers don't know what it is. So sometimes family therapy is ordered versus reunification therapy. But why would you use court-ordered family therapy? Well, that would occur in most cases where a child is still coming to your home. And they have started to pull away. They don't necessarily want to be there. You see a huge change in their demeanor. You feel like you're losing connection with them. However, they are still coming to your home. And in these cases, the court would not necessarily order reunification therapy. If you have a child that has stopped coming to your home, maybe a couple weeks, maybe a couple months, maybe a couple of years, that kind of case really does require reunification therapy because very specific things need to happen in order to reunite that child with a target parent that they have not been with for a very long time. Now, why do you need a court order at all? Well, what I found in these cases is that very often, if you try to do them voluntarily, the favored parent in these cases will sabotage the case. Once you start to talk with them about any of the kind of behaviors that they are engaging in that are keeping the child from having a relationship with the target parent. Therefore, they will drop out of therapy and they will do what I call therapist shopping. They'll start looking for another therapist who will fall in line with their particular way of thinking about the child. That, the other therapist, they just weren't listening to my child's feelings. They don't really understand how this is for them. And this will continue to happen. This is particularly detrimental later on to any therapist who maybe comes in and tries to do reunification, because now the child has talked to God knows how many therapists. They are therapy fatigued. They don't even want to talk to you anymore. So this is very counterproductive to doing good therapeutic work later, which is why getting it ordered early on in a case is very helpful, and getting it ordered with somebody who knows what they're really doing, which I will talk about in a minute. So you need a court order because otherwise the favorite parent is not going to stay engaged in the process and they're going to sabotage it. Now, the other thing that's important to do in the order is to define reunification therapy and court-ordered family therapy. In regular family therapy, you have both mom and dad and the kids and whoever else in the room together. That is not what you do in these kinds of cases. If you're doing reunification therapy or court-ordered family therapy in these cases, you would not necessarily have both parents in the room ever, maybe occasionally. But mostly what you do is you need to be able to have the ability to do sessions with the favored parent and the child and the target parent and the child. And that is more appropriate. And a lot of times they want to define this in the order because people get a little worried about that. And so that leads me to number 2. And this is the other biggest error I see when these court orders are made. And that is that both parents are not included in the order or the therapeutic process. A lot of times the favored parent and the favored parent's lawyer says, well, the child is having a problem with the target parent. They're the ones that need the counseling and the therapy. Whereas that's not the situation at all. These are cases that are not about just individual issues with the child. This kind of a case involves looking at the whole family dynamic, and you've got to treat the whole family dynamic if you're really going to help this family or help them to reunite. So you have to have both parents engaged in the therapeutic process. And actually anybody that's living in the homes with the child. So you could have a grandparent, you could have a step parent, you could have a boyfriend, a girlfriend, nannies, whoever it is. that's having ongoing, interaction with this child in either one of these homes, you need to be able to have those people come in and work with you, because you don't know exactly what their influence is on this situation. We call these people shadow figures. They're in the back, they're influencing the cases, but sometimes you don't really know exactly how. So you've got to be able to work with everybody in the system, and you need a good order that talks about that. And that leads me to the third biggest error I find in these cases. And that is that the target parent does not take the time to educate themselves about parental alienation and what they need to know about the people in their community that are treating parental alienation. Because when you go to work with your lawyer, you're going to need to put together a good order. And when you put that order together, you are going to want to put forth really good people in your community or in your area that are going to be able to help you with your case. So you've got to educate yourself. You've got to get out there and research the people around you that will be able to take your case on. I had a client not too long ago. She was in a situation of very severe alienation. She really took the time to learn all the people in the community that would be appropriate for her case. And when they went into the judge, they had the names, they had the people. She lined up exactly the people she wanted to. And we were all able to work together to resolve this case. The more you have people on board that know what they're doing, the more likely you are to set up an appropriate situation, therapeutic situation, where a child and a parent are really going to be able to repair their relationship. Here's another thing. Don't depend on your lawyer to know what to do or what to put in the order. A lot of times lawyers will contact me and say, well, what do you want in your order? That is absolutely the best case scenario, because I can explain it and I can tell them why. But don't depend on them to know these things. It is really important that you drive this situation yourself. You educate your lawyer, you give them information, and that before you ever go into court, because it takes so long to get in, and who knows when you'll get in again. You really have to have everything lined up and ready to go. So here we go. Error number 4, not getting a therapist that understands parental alienation. Now, I know Mary talked about that, and of course, this was a huge issue in this case. And I think one of the biggest issues, and she referred to this too, is that in this case, the target parent knew that parental alienation was a huge problem. But I think a lot of times what goes through people's minds is, I've spent so much time going to court, I don't have that much money, I've really got to use somebody on my insurance. This is one of the biggest mistakes made in this particular kind of a case. You may not get very many chances to actually get into court and to really take action steps that will help your case. If you can get a good therapist on board that really knows parental alienation, you are way ahead of the game. And oftentimes you think, oh, I'll use somebody on the insurance because it will save me money. Well, what happens is they get on the case, they don't know what they're doing, they mess the case up so badly that later on you have to go back and pay thousands of dollars to go back to court and try to fix the situation and find somebody else. And again, now it's another person the child has to work with, more fatigue for the child. So let's talk about, if you need to choose a therapist that knows parental alienation, what would you be looking for? Well, some of the things I think you'd want to ask them about are things like, oh, what do they know about the 5-factor model? What do they know about the 8 manifestations of children that are suffering with parental alienation? What do they know about the 17 strategies that are often used by a favored parent? Do they know any of the work of Amy Baker or Warshak? And by the way, these are good things to educate yourself around before you actually start asking these questions. Another good one is, are they a member of PASG, which is Parental Alienation Study Group? This is a group of people from all over the world who train and work together all of the time and keep up on the latest research. But here's one of the really important questions to ask, and I get asked this a lot, and I think it's really smart, and it has to do with the intake process. Here's why. The worst case scenario for these cases, and like I said, you may only get one shot at this, is that you get ordered to do family therapy with the child, you get into the room with the child, there's been no preparatory work, and they just start having a joint session and it goes off the rails. The child's angry, they're accusatory of the parent, they may be verbally abusive. And what happens is there's just nothing therapeutically helpful that happens in this situation. So when you are vetting this, please ask about the intake process. The best intake process involves the therapist meeting with everybody in the family, taking background and history, and doing it individually. Spending time understanding what their concerns are, what their worries are, and what level of anxiety does everybody have, because that also can significantly impact these cases. Once you understand that, I tell them, well, now I'm going to start coaching parents. I need to coach the target parent to be ready for what could happen in the first joint session. I need to coach the favored parent on how to support this process with the child. I may even need to do a therapy session with them or to do that. And in that way, you're setting up the best possible outcome for your case. If you don't hear a therapist telling you that, and really then discussing how they're going to get everybody together, I think that should be a really big warning sign going off in your head. And I think the other thing that happens with a therapist that does not understand what parental alienation is that they don't realize it's their job to hold the favored parent responsible for their behavior. If they're not participating, if they're not bringing the child, if they're not willing to follow the court order, these are things that have to be discussed with this parent. And oftentimes, that is something a therapist will shy away from if they do not understand the dynamics in a case like this. So I have all of this stuff put in my order. It's very clearly outlined for both parents to see that I'm going to be doing coaching sessions, that I'm going to ask them to be meeting with their child, and that everybody is going to be asked to be involved. Number 5. This one also is one that really, I'm just hoping that over the next few years, we can really get the message out about this one. Parents, when you go into court, don't just ask for individual therapy for the child. It's just like I talked about before. Individual therapy doesn't address the resist-refuse dynamics that you see in these cases. You do not want to make the child the identified problem. It is a family systems problem. It needs to be looked at from a family systems perspective. Therapists that don't understand this dynamic just make these cases so much worse. And once again, later on, somebody who maybe takes over the case is going to be digging out of that mess. So why do they make it worse? Well, there's a term in our business called the negative advocate for the child. And the therapist oftentimes is trying to bond with the child. They want to build that relationship with the child, and that is appropriate. But they don't have any knowledge about maybe the 8 manifestations of a child who is being alienated. And then when they start to hear all the negative things from the child, they start to have a lot of really negative feelings about the target parent. Also in these cases, oftentimes, that individual therapist never even meets the target parent. They only ever have contact with the favored parent. They only hear the story from the favored parent's perspective, which again is a very skewed perspective of the whole case. They just don't have all of the information. So it is a very biased sort of situation. And it is oftentimes one of the biggest issues. I have a case right now where, I have a parent who really does not want to support the therapeutic process. She's the individual child's therapist. She's totally against reunification. I'm just beating my head against the wall trying to help with this case. I can't get anywhere with it. They don't oftentimes either, the individual therapists, really understand the legal system, and that therapists and the legal system have to work together. Oftentimes they're just scared to talk to lawyers. Once the lawyers start getting involved, they get off the cases. They just ditch the case. I don't want to be involved anymore. They put up all kinds of barriers. Again, this is so detrimental to the case. We have to be able to work together. Sometimes you are going to have to go into court and talk about these things if you are working with a child. And they oftentimes will quit the case and then the child's just left high and dry, right? Once again, lost the therapist they've been working with for 2 years. Just had that happen this past week. And I think the other thing that is really, really true for the individual therapist, it's really not their job to hold the favored parent accountable for their behavior. They're not there to be the therapist for that parent. So this part of the dynamic is really never going to be addressed in individual therapy with the child. Now, in this particular case that Mary presented to us, only individual therapy was ever ordered. There was never any family therapy ordered, as she said. And it even took a while to get individual therapy going. And when they did get it going, well, unfortunately, the person that was put on the case didn't have any idea of parental alienation. So the number 6th error we see is that you don't have a knowledgeable professional coordinating these kinds of cases. Now, in the case that Mary presented, they did try to get, and I think they actually did get, an amicus on this case. But unfortunately, I don't think there was a lot of case management that was done by the amicus. And if you have a really good reunification therapist or a really good guardian ad litem or an amicus, and in some states there are case managers that work on these cases, then you have a much better opportunity to all work together and coordinate this case and really help the case to move forward in a positive way. There's so many things that can fall through the cracks, as you can see in this particular case that was presented, and you've got to have somebody that keeps the ball moving along. The other problem is that if you don't have somebody really good that's coordinating the case, there's not going to be anybody holding everybody accountable for their part in the process, particularly the favored parent who oftentimes doesn't want to come and doesn't want to bring the child. You also don't have anybody that's educating the parents about co-parenting issues. When I do reunification therapy, I realize that I'm going to have to train these parents to actually co-parent together. I will often model how they can co-parent with each other, and then I will tell them, okay, now you're going to take this over. You need to start communicating through Our Family Wizard, app close. You have to start having these kinds of conversations with each other because I'm not going to be here to do this for you forever. I've got to teach you how to do it. The other thing that happens when you don't have a really good case manager or somebody coordinating is that nobody educates the parents on the effects on the child of losing a relationship with a parent that they previously were close to. This has a significant impact on a child. I oftentimes have to spend a lot of time trying to educate a favored parent about how this is going to impact their child if they don't work with me. And tip number 7, and this is really the 7th error, is that you don't get your own therapy if you are a target parent. It is not always possible to get family therapy or reunification therapy. And sometimes the only thing or avenue you have open to yourself is to do your own therapeutic support work. Here's the problem. If you are a target parent, you probably are at the point where you are extremely angry, frustrated, anxious, overwhelmed. And what happens is over time, all of that spills over onto your child and maybe even your ex. And every time that it spills over and you show that side of things, they just say, see, that is the problem with you. It reinforces all the negative narratives that have already been started about you in this case. It just makes you look worse. And it's unfair because you have every right to feel the way that you feel, but it is going to be looked through a very different lens, and you have to be prepared for that. And if you have a good therapist on board, they'll help you with that piece of it, because you cannot parent the same way you would normally parent if you were in a 2-parent household and you were together. You have to parent completely differently in these situations. And you have to be at the very top of your parenting game. You need somebody who's going to guide you through that process, because if not, very, very likely you're going to make mistakes along the way that are going to cause you to become even more estranged from your child. Okay, so now I would like to advocate for the same thing that Mary did in her presentation, which is early intervention. If you can at all get family therapy or reunification therapy ordered in your case early on, this is going to be your very best way to actually prevent a lot of serious alienation from occurring. Because if you have the right to meet with your child and to do family therapy work, then that therapist, if they really know what they're doing, can address the issues that are coming up, the narratives that are being started about you that are false. And you can work on that together and prevent a lot of the damage that gets done in these cases. So I always give that advice to my families. And the favored parent obviously will continue to put forth those false narratives. And if you have some family therapy involved, hopefully that also can be addressed by the therapist. But here's the other thing, and I think Mary alluded to this, it is so much easier to treat these kinds of issues when a child is younger. By the time a child gets to about 11, 12, 13, 14, these cases get to be incredibly complicated. I have so many cases where the child is 11 or 12 years old. I think one of the reasons in Texas that we may have that issue is because the children unfortunately believe that at 12 they can choose which parent they want to live with. That's not really how the law works here, but that is what they are told by a parent. And so it seems like that is the age at which they really get dug in, and that the favored parent really works on, planting all of those false narratives. So anyway, I know we'll be talking a little bit more about some of these things later, but I'm going to hand this over to Chris.
That was great, Lisa. I am so glad to hear that you really focused on how lack of early intervention in these matters early in the judiciary case with family therapy and a family systems approach is such a key factor in trying to prevent this train going off the tracks.
And those professionals are out there. I mean, even though the research has been developing and continues to develop, especially longitudinally on the long-term effects on these kids, it's out there. And those professionals are around. They can be found.
All right. So, Chris, I think you're going to talk to us next.
I am. We're going to talk about the court case itself and see how it went off track and very visually. Take a look at that case. Great. Thanks, Lisa and Mary. We have a great balance here. We're going to go talk now a little bit more about what happened specifically in this case and generally in many cases as they go through the judiciary and go through the legal process. Unfortunately, many people often say, the court screwed me, or I got screwed in court, or it was, it all went awry in that system. And what I think you need to remember as parents and as active parties in this case, as Lisa had explained, is that no one is going to take responsibility for your child as much as you are. They are tools that you use. All of these people involved in your case are tools. It is up to you to take the responsibility for making sure that your child is no longer abused through this process that we call parental alienation. And so we're going to talk about some of that and the way that that happened in this case and in many cases. So we're using the state of Texas Family Code as the basis for this because we are all here in Texas, but this is true in most jurisdictions. And so the process is very similar. People file an initial petition and then the courts come in and say, okay, we're filing this and make sure nobody destroys the home or does horrible things to the assets while we go through this. And then the other party's served and they answer what they need to say about whether they agree with that original petition or not. They might have a counter petition on top of that. Many times, always in the state of Texas, if there are children involved, we will see that there is a mediation before temporary orders. And then the temporary orders come. If they can solve everything in mediation, great. That's a great thing for parents to be able to resolve things between themselves regarding their family. Because it will continue to be a family even after the process is done. When everyone else is gone, they need to figure out how to work together. And so mediation kind of sets the tone for that. which is great. Those temporary orders that are going to be ordered based on that mediation, or if there is no agreement or no mediation, the orders will be finalized. There will be a hearing that finalizes those temporary orders. Don't let this be a point where people refer to, oh, this is just temporary, we can fix this later. All through the process, you need to be diligent about advocating for what you want and not making up for what was done. And temporary orders is the first time that you'll have an order put in place that orders you what to do, orders visitation with your child, orders access to your child and how and where and what information needs to be shared. And it's important that those get to a good start with equal access for the parents and the parents remaining in the lives of those children. And then again, final hearing, there'll be another chance to mediate and work things out for yourselves. And the final hearing comes and the final orders offered. At any time during that process, there will be lots of discovery. So generally this process, from the time that we start to the time we finish, is well under a year, 6 months to 9 months, if everything is going well and people are working and moving the process forward. And so kind of keep that in mind as we talk about this 6-year case that we've been dealing with, in terms of what's finalized and what is good and just for the family members, specifically the parent that has been targeted. And so that usually happens. In some states, in the state of Georgia, for example, there's a year in temporary orders. So your state may vary in the amount of time that this process happens. In the state of Texas, you can be finalized within 61 days on the 61st day if everyone's in agreement. And so it can vary based on that jurisdiction, but generally there is a time limit to that, and it's supposed to be expedited if it's possible. And in this particular case, with this young man, this child, the initial petition was filed, and there you go, almost 6 months, so a little bit over 6 months, well within a year, the divorce was finalized. And there was discovery, and they followed that process, and everything seemed to be good. Again, remember what Mary and Lisa both referred to, the age of the child is important. And in this case, the child was very young at the time. And so possibly, even though there was some predisposition towards some of this alienating behaviors, they weren't coming through because the child was very young and the child was able to adapt to both parents' environments. And so the parents were doing very, very well through those early years until Christmas time of 2015, which is when we saw the first modification. So remember, that's what we're looking at for the most of the process. They worked through the process. This is what the next 6 years look like. What a mess, right? This is a timeline. Seems a little crazy. If you look at many of the timelines, and it's important to do this, either your attorney to do this, a case manager, or someone involved in the case, to kind of put things on the timeline, you can see how it progressed and escalated, where initial petition was followed right after Christmas, and many of the issues that came up came out of that time with the child, where either issues were brought up that the father or the mother, whoever's the target parent, was not seeing when they didn't have undivided time with the child, that they were able to have during that access time during vacations. But early on in the case, these parents were looking for motions for enforcement, red flag, access to the child, motion for psychological violence. Something's being done that's affecting the child's mental health. A motion for a parent facilitator or a parent coordinator, someone to intervene here and help the family. These cries were going out. It wasn't happening. And then finally, there was a hearing to have a psych eval done. And you can see those round circles, those oval circles of continuances in that case, where it was continuance, continuance, continuance. And again, when we had hearings, they were often reset. So the timelines were really crazy. From February of 16, the final order was in 17, a year later, for a modification, an initial petition for modification on some very basic things. Let me get some help, one parent was saying. I need help, something's happening. Early on in the case, 2016, we move forward to 2023, and it is escalated. More continuances, more need for discovery, another motion for continuance, another motion for having someone involved with as a parent facilitator, as well as some motions for enforcement of that thing. Mediation was held, and in all of these cases, these were agreed orders that came in. All of these stars here were agreed orders. So at some point, the parent felt kind of beaten down in terms of what they were doing in the case and agreed to things maybe that they wouldn't have agreed to outside of it, or talked into those things, right? So it's important that you stay vigilant. Let's talk about what would have been different if these parties in the case had been more active in this litigation. Let's talk about the attorneys first. Obviously, education about parental alienation was lacking. Many of the attorneys involved in this case didn't have the access to, or the need, or the information about parental alienation. We do have that research now. We do have the studies done. We know effects are on the child. And so the parent that's seeing it can find that basis and make sure that they're advocating, making sure that they're choosing an attorney that can see that and explaining what exactly is going on in terms of behavior. Another thing that happens in the court system is that once a motion is filed, there might be requests in that motion that the courts are going to respond to. And it's up to that attorney to bring in previous things as discovery or as part of that motion to make sure that the court sees the continuum. That continuum wasn't entered. So each time it was like, Groundhog Day, right? Where the courts are coming into the case as if it's the first setting again, or something's happening, not looking into the past history unless that was entered into. And the attorneys got very involved in that. There were repeated delays and continuances. Court hearings were reset and reset and reset, and the motions for continuances were ongoing. And that affected the court case greatly in terms of getting expedition for this relationship between the parent and the child. And remember, during that time that those delays and those continuances are going on, the behaviors and the tactics being used with that child are continuing. So that child is being left unfettered in the status quo that is doing damage. So it's very important, not only for the process and for the adult's mental health and the adult's need to get this forward, it's very important for the child to have that moving forward so that there is an answer and that things are changing for that child and they're not continually being reset and giving unsupervised and unfettered access to that child to do more damage. The failure to follow through with appropriate referrals. There were many times in this case that there was a motion for a psych eval. Was it appropriate? Did the psych evaluator know what to look for? Did they have the information? Was the parent facilitator knowledgeable? Was the therapist knowledgeable in dealing with parental alienation? And that follow through wasn't there. And again, each time a motion was filed, then there was a temporary order, a final order entered, the case was done, so there had to be another motion to appoint an attorney ad litem again, or an amicus for that child, or a therapist for that child, or any other referral that was going to happen. I had said early on, in this particular case, there wasn't an active participant that had knowledge of parental alienation till the very end of the case. Is where we are now, 4 years, 5 years into the case. And some of that was that, and some of those delays were because of the cost for the client. This is extremely important when you look at who's monitoring this case. You have to take an active role with the case and let the attorney do their job as an attorney, but save them time by doing some of the research and be responsible for being knowledgeable about what goes on in the case and what's going on with your child that is resulting in these court issues. Mediation often wasn't utilized properly in this case. The parties were beaten down. There's research and studies showing the effects of parental alienation and on the target parent, and in many cases, the case has been made for that this is a form of domestic abuse, improportionate balance of power within the family, And one parent may have the means to stay this through and bleed the other parent through the process so that they have to give up because they can't afford to fight it anymore and can't afford the resources. And in this particular case, I think that was one factor when they got to mediation. They'd rather settle it than have the cost of a full hearing that was going to be the result of not having a successful mediation. And so possibly they gave some concessions during mediation that they might not have. Again, keeping yourself strong, keeping yourself healthy mentally so that you can stay on top of these issues is important. I want to say one thing about attorneys before we move forward, and that is that many parties believe that they can save money. They know the case the best. They can serve as their own attorney. If parental alienation is a factor in your case, please do not be pro se. Do not represent yourself in these cases. You will not be able to do it effectively. You need to be the client and you need to hire an attorney to do that for you. And so those pro se cases, again, the imbalance of power is even greater when one party has an attorney representing themselves and the other party is trying to utilize all the resources of an attorney. The ad litem in this case, education again, early intervention and education of all of the professionals is key in many of these cases. But the ad litem or the amicus, depending on which case you're, needs to be involved in the studies and have some knowledge about parental alienation. It wasn't the case in these cases. There were infrequent visits with the child. Sometimes the amicus attorney or the ad litem is very involved with children, and that varies from jurisdiction to jurisdiction. Many times you'll hear, oh, this ad litem or this amicus is great, and you want them attached to your case because you've heard good things about them. And that may happen, but the larger the caseload, often more infrequent visits with the child. Some attorneys who serve as amicus attorneys or attorney ad litems will only see the client when the court case is coming up. Well, that damage is being done ongoing. So they need to have some experience and knowledge about parental alienation, and they need to be visiting with that child to find out what's going on. Again, the ad litem and the amicus are agents of the court. They're court appointed and they need to be utilized. If they are attorneys in the case, then they need to be able to go ahead and put in motions for enforcement and have that power to file motions on behalf of their child that they're representing. And many times they are not utilized in that respect. Easy to understand that the parties in this case, emotions were high on both sides. One was very in control and the other one was just reactionary to what was going on. Again, in a lot of these cases, the person that is being targeted will often be the person who has to bring the case back to court for enforcement. They're not being able to see their child. They're not following the court orders. They're not having access the way they need to, or that is in the current court order. And so they're the one that's being seen as the villain because they're having to file all of these case motions and bringing that other party back to court. And why are they bothering me again? And why are they creating more strife in our family by taking me back to court again? When the balance there was that they were not getting access and they're just wanting to see their child. But they look like they are the person that is instigating the issues in the case. And so emotions and targeting can be very, very high in these cases, and it's very difficult to separate yourself. Again, so important to make sure you're taking care of yourself, that you're able to have the support and get the support that you need, whether it's through family, friends, therapy, whatever that looks like to you, but making sure that you are staying in control and doing the best job that you can. This comes down to being able to separate your emotions from what needs to happen in court. Again, another reason why you cannot do that as your own attorney, but you need to be able to be in charge of that case and moving that case forward. You can't do that if you're not taking care of yourself and you don't have your emotions in check. Financially, many times these cases, and in this particular case, decisions were made about therapists. They were decisions made about mediation based on finances and how long they could continue to do the case. This is a fight for your child. This is a fight for your child's mental health and well-being for the rest of their life. It's worth the money that you put in. And being able to say, I value my child more than I value going on that vacation this year. I value my child as the most important thing and the most important resource I need to invest in is what needs to happen. The finances are prohibitory for some parents. And so you need to take a look at that and find out what you can do to get access to your child. The court system is the means by which visitation access is going to be established. And so being able to have that as your priority and put that first is important. And figure out where those other areas are. Don't scrimp on those professionals that need to be brought into the case. Don't scrimp on the therapist that is educated about parental alienation, or the case manager, or the services that you're getting, because those will help you to compress those cases, get them on the right track, and get them finalized even quicker, which is going to cost you less in the long run. It's obviously a factor, but in this particular case, it ruled most of the decisions that were being made. Control of the case was left to the attorneys. Sometimes parties will say, well, that's why I pay my attorney the big bucks to do. Well, there's staying power there that is limited when the attorneys take completely over the case. They're going to roll the case in terms of litigation. You need to make sure as a parent that you are in charge of that case and making sure that you are focusing it where it needs to go, along with your attorney, and utilizing all the tools, the attorneys, the attorney ad litem, the therapist, to get you to the end point of your game that you need in that particular court case. The judiciary in this case, education, again, about parental alienation was lacking. Now, there's no way, because we have this whole barrier between judges and what they can see and hear, and ex parte communication. You're not going to be able to communicate the judges about that, but you can reach out to the professionals that are involved. The professionals that have been brought into the case can absolutely use the court system to educate the judge as well. And in their reports, making sure that reports are entered into the case file so that the judge is seeing all of those. They're limited to the scope of that hearing, and that's just one of the boundaries that they have. So if petition is brought up and there's a motion for enforcement, they're not going to read through all the back history unless it's been brought into the case already. They're not going to find out what's been going around. That's not their job. So they're going to focus on what is before the court right now and what is that they're asking the judiciary to rule on. The judge in this particular case failed to recognize that the child's reaction was symptomatic of something bigger going on. And so the focus on the mental health resources for this child was simply in therapy. Get this child into therapy. Get this child the help that they need because they have anxiety. They're going through a depressive mode. And so those were all symptomatic, and those of us who deal in the field of parental alienation know that many times that's how it comes out with the child, and that's the symptoms that we see with the child, and that's the reaction of the child. But there's a larger issue that needs to be addressed in order for that child to move forward. And many times that's the symptom is symptomatic of parental alienation. And so focusing only on that child and not on the goal of the family, and taking into account all members of that family and getting into a therapeutic mode with the family members and healing them and moving them forward is really important. And so the judge in this particular case said there must be something really wrong going on here, because this little boy is acting so negatively towards his father. Something must have happened. And so again, the role of the judiciary is to do what's in the best interest of the child first and foremost, and to do no more harm. And so when they're looking at the best interest of the child, if they feel that there's something more going on, they're going to limit the access and make sure that that child is taken care of, get that child services. Again, the child becomes the primary goal in their mental health, where it really is a family dynamic that needs to be addressed. The key in that situation is making sure that the professionals that are involved are knowledgeable about parental alienation and have that background. So all of these factors enter into it. So the takeaway from me is to make sure that you stay in charge of your case, that you move it forward, that you use all of the tools, the court system, the professionals involved, the resources that you have, and your mental health and mental well-being to move forward for your child. Many times you'll only get this one chance. And so as I wrap up here, we're gonna spend some time talking as a roundtable about all of these issues together and answering some questions and have some dialogue about this case in particular. But we've talked a little bit about the overall, we've talked about the research and some of the beginning of this case. We've talked about the therapeutic mode involved. We've talked about what's happened in the court case. So let's take some time to talk about overall what could have been better and what questions arose out of this case that are very applicable to most cases of parental alienation.
Chris, that was an excellent presentation. Thank you.
Absolutely.
What was so eye-opening for me was your visual representation of the judicial process and the massive amount of
Absolutely.
activity that has happened in this case over the course of 6 years and counting. That was very, very eye-opening.
Activity in the court on the document, but inactivity in terms of movement for this case.
Right. It's
Yes.
just so stifling.
Yes. And I think what happens for me is seeing that visually really underscores that the development of toxic stress is there. And it has been there. This child has been under tremendous pressure, as part of this ongoing parental conflict and the role of the judiciary, which parents always have to conform and act in certain ways or not. And so in my mind, I'm seeing, wow, there's a lot of potential neurological damage being done as a result of toxic stress.
And I think the thing that's really kind of confusing to a lot of parents is, well, the child looks fine. They're in school, they're making great grades, they're in activities, they're in youth group, everybody's doing fine. It would be better if we just didn't continue to even try to do any type of reunification process. But it doesn't really look at the long-term effects of what is going to happen to this child if they don't get an opportunity to try to resolve this issue and rebuild back that bond with that parent.
Right. And I've also heard kids tell me that they feel like they're in this pressure. Yes, I'm having to keep my grades up. I'm having to stay on the team, but I just don't really want to, I don't have any passion for this stuff anymore. They're dying inside, but they're having to perform to keep things looking right.
Yeah, a lot of times later on, you'll start to see the depression and the anxiety build, and then they will start to crash. Sometimes they end up, even being hospitalized because they're having so many difficulties.
So what are some of the outward behaviors that you see with kids as a therapist that might be indicative of that stress coming out?
Well, I have a lot of kids have very severe anxiety disorders.
Yeah,
and so I think that is a huge issue.
all the time.
Depression, for sure. I've got a child right now that's so ill, she's sick every day and can't even get to school. You see a lot of cutting, sometimes eating disorders.
Self-harm, right?
Yeah, a lot of self-harm, some cases substance abuse issues. But I would say a lot of self-harm, anxiety, and depression are some of the three biggest things.
So it makes a lot of sense when a judge or when some of the attorneys look at the facts, doing well in school, still on the team, a high performer, the kid must have a problem. The kid needs therapy, right? Not looking at the family system as the root cause of that.
And the research, I think that's one of the things that the judiciary lacks is just an understanding of the research, because everything that you just said about, psychological consequences, behaviorally or emotionally, is well grounded in the science and research. That's all predictable. We know that these are the outcomes,
Right.
From the result of toxic stress.
And I will say, just from being in the courtrooms myself with the judges, I think they like to hear this research. In the last court hearing I was in, the judge said, hey, can you tell me the research on the long-term effects on a child who doesn't reconnect with the parent? And fortunately, I was able to say that to her very quickly. So I do think it's important to educate every opportunity we have.
We have the opportunity to give them facts.
Yeah, exactly.
Exactly. And that's what judges like. They
want facts.
Facts.
Absolutely.
And research-based information.
Yeah.
Okay, so what are our takeaways from this? What are your takeaways?
So education, 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 of the judiciary, of the attorneys, of all the parties involved, working together. making sure that the target parent stays healthy, right? So that they are not becoming the person that that other party is accusing them of being, right? And reactionary, and just staying in control of that process.
Yeah. Well, I think for me, it has a lot to do with please try to get family therapy or reunification therapy ordered versus individual therapy, which is where I think a lot of cases get derailed. I also think it's really important to get a very good, tight order. And that order, my third one would be that you absolutely have to have everybody in the family be involved in the treatment process and have that be stated in the order.
And for me, intervention as soon as possible. Even though the system doesn't look that broken, the child doesn't look that bad, the behaviors that are being alleged don't look so severe, intervention early in the process is so critical. And we are much more of a reactionary or a defensive type person than we are an offensive. Let's be offensive. Let's do the things that we know need to be done, even if it doesn't look like they need to be done at that time.
Right. Well, thank you so much for being with us today. And we are so glad we had the opportunity to share our different perspectives with you about these really difficult parental alienation cases. And we want to thank Family Access as well. And we look forward to hopefully having other conversations with you in the future.
Thank you.
Thanks.
Thanks.